This week's case study presentation is Franklin versus Gwinnett County Public Schools out of Georgia. And this is a case where the U.S. Supreme Court ruled that students who are subjected to sexual harassment in public schools can sue for monetary damages under Title IX of the Federal Education Amendments of 1972. This was the first case where the Supreme Court said that monetary damages could be awarded in cases involving Title IX. That's why sometimes it is labeled as a seminal case, which means strongly influencing later developments. And obviously, that's what paved the way to be able to sue monetarily under Title IX. Here's a few facts of the case. The case involved a young lady named Christine Franklin, and she was a female who was a sophomore in high school at Georgia's Gwinnett County Schools. She alleged that through 1996 to 1998, she was subjected to continual sexual harassment and abuse by Andrew Hill, who was a male teacher and a coach at the school district. And the allegations that Franklin made were that Coach Hill engaged her in sexually explicit conversations, forced kissing, and coercive intercourse on school grounds. Franklin claimed that although administration and teachers were aware of the harassment, they didn't do anything to stop it. In fact, they even discouraged her from bringing charges against Coach Hill. So then the school did launch an investigation, but it was closed when Coach Hill resigned in 1998. So Franklin then sued for monetary damages under Title IX, which states that no person shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. After a federal trial court in Georgia and the 11th Circuit rejected Franklin's claims, the U.S. Supreme Court reversed the decision in her behalf. And some of the court findings are on December 11th, 1991. The case was argued before the Supreme Court, and when taken into consideration the issue of remedies, the court followed the traditional presumption that absent clear direction to the contrary by Congress, the federal courts have the power to award any appropriate relief in a cognizable cause of action brought pursuant to a federal statute. The court found no evidence that Congress intended to abandon the traditional presumption when it passed Title IX. And moreover, the justices dismissed the notion that allowing monetary damages would extend the federal court's power into an area that belonged to the executive and legislative branches. The court rejected the argument that the traditional presumption did not apply in Franklin because Title IX was enacted pursuant to the Congress Spending Clause power. Now, while recognizing that funding recipients should be given notice before they're held liable for damages for unintentional violations, the court nevertheless found that the Gwinnett County Public Schools intentionally discriminated against Franklin on the basis of sex. And then as a result, the court pointed out that the problem of notice was not involved, and the remedies were not limited by that spending clause. So the court therefore determined that if it had the authority to grant all necessary and appropriate remedies to private parties in teacher-to-student sexual harassment suits, including monetary damages. So the case was later resolved with an out-of-court settlement, and the terms were never disclosed. The questions I would have, especially if I have to argue both sides, are, why were rape charges never filed, especially since it went on for 2 years? And maybe the words forced kissing and coercible intercourse are the key words, I don't know. Or maybe it was the fact that it went on for 2 years, maybe they felt like, since the young lady allowed it to go on for 2 years. I don't know. It says, was Coach Hill, or I ask, was Coach Hill ever sued? And if no, You know, why not? Why did they just name the Gwinnett County Public Schools in their lawsuit? The implications for the athletic director here would be the fact that, you know, Ms. Hill says there were other students who were subjected to sexual harassment, and she says they did absolutely nothing to stop it, and they even discouraged her to keep from reporting it. You know, and if this many people knew about it, it has to be assumable that the athletic director had to know as well. You know, and in my opinion, he should have been held liable monetarily or lost his job, you know, just for poor judgment or character. You know, so I personally would have started with a brand new athletic staff, because, you know, if it went on for 2 years and other students were being sexually harassed, then I would dare to say that most of the coaching staff, and I don't care, men's and women's, had to know that it was going on. So I'm glad she won and got her day in court.